Greetings and thank you for joining me. This video will focus on the major issues that people in H-1B status encounter, how to manage those issues while maintaining a focus on career. At the end of this video, I'm going to include a segment for those who are interested in lawful permanent residency, also called the green card process. My name is Chad Graham. My law firm focuses exclusively on employment-based immigration. We help companies secure immigration benefits for their employees from other countries. If you're not already subscribed to our channel, you should do that so that you can be notified as we post new content. The way to do that is to be sure that you're logged into your YouTube account and then click on the subscribe button underneath this video. With that, let's jump into the fun stuff, which of course is maintaining status. All right, maybe maintaining status isn't the most fun topic, but it is fundamental. If there are changes to your H-1B position, an amendment might need to be filed with USCIS prior to that change being made. Now, the areas where this comes up are as follows. The first is changes to location. Now, if you work for a large company that has a big campus and you're working in building A, you're going to change to building B. Even if you're moving to a new department and a new manager, an amendment is probably not required based on change of location. But if you're moving from your company's office in California to an office in Texas, then yes, an amendment is going to be required. Amendments based on location changes can also happen within state. It really comes down to whether that change of location is outside of the current metropolitan statistical area in which you work. The other area we see this come up sometimes is where somebody is working at an office location, they decide they're going to move to working from home or vice versa, or some sort of a hybrid combination. In those instances, we would likely need to look at an amendment as well. The next area is changes to your job duties. Now, if you're working for a company and you're taking on promotions, additional responsibilities, maybe even getting some direct reports, those changes are typically fine and don't always trigger an amendment. The rule of thumb that we like to use is if your job duties are changing by more than 50%, then we should look at an amendment. Next is changes to salary. With each H-1B, there's an LCA, labor condition application, that needs to be included. Within that LCA, there's a prevailing wage requirement. What that means is there's a dollar amount that your sponsoring employer needs to pay at a minimum or above in order to be in compliance. Now, some companies decide to do compensation restructuring from time to time. And if they are reducing base salaries in favor of a more incentive-based formula, let's say where you can receive performance bonuses or RSUs, something like that, where your base salary is coming down, but you have the potential to earn, let's say, even more money. The issue is that USCIS will only look at what is sort of like your guaranteed salary, that base salary. Even if you could potentially earn more, that won't be considered. They'll only look at your base salary. And if that base salary is dropping below the prevailing wage, that could be a problem. Last is changes to the number of hours that you're working. So let's say you're a full-time employee, you decide you want to go back to school to get your master's degree, you're going to work part-time during that time as well. An amendment is going to need to be filed so that you can make that change to part-time work. Now, if you are in a situation where an amendment does need to be filed, it needs to be filed and received by USCIS prior to the change. So if you're working from your California office, don't show up in Texas until that paperwork has been properly filed. The main thing I want you to take away from this segment is that you should be able to pursue your career goals without feeling like your immigration is inhibiting the things that you want to do. It's just that you need to plan ahead, make sure that HR is informed and that your immigration attorney is involved so that paperwork and everything is done properly and on time. On that note, what about changes to the employer of record? So if you're working for your company and you decide you want to take a new job at a different company, that new company is going to need to file an application to transfer your H-1B to them. The timing of this can be tricky. Once you notify your current employer that you're leaving, they're going to need to have that H-1B withdrawn. By law, they need to do that. And then if there's a problem with the case with your new employer, and that case gets denied for some reason, then you could find yourself in limbo and in a bad situation. So in some cases, I recommend that the H-1B transfer be approved prior to making that move. This is an area where a conflict can arise between the company and the employee, because the company typically wants a person to start as soon as possible, like when USCIS issues the receipt. Whereas the employee might not feel comfortable with that. They might want an approval before they make the change. So the question is, should the company pay the more than $2,800 extortion fee that USCIS charges, also known as the premium processing fee, to have the case approved within a reasonable amount of time? Now, some companies do this as a matter of course. On any H-1B transfer, they'll file the case with premium processing. Great. Now, what if you're moving to a company that either doesn't do that or does it on a case-by-case basis? In your case, is not going to be filed with premium processing. You have a couple of options. The first is you could pay for the premium processing cost yourself. You might decide that it's worth it to do that. You're really excited about this new position and you're willing to incur that cost to make the change. The other option is to talk with an immigration attorney to see whether the move is a high-risk move or not. If the role that you're taking on at the new company is essentially the same as the role with the previous company, that would be considered a low-risk move, and you might decide that it's worth it to make the change, not pay the premium processing fee, and just wait for the case to be approved several months later. I recommend that you keep a copy of your H-1B petition along with the approval, not only so that you have a completeness of your immigration record, but for instances like this, where you or your immigration attorney needs to go back and see the previous position that was sponsored. Next, let's talk about international travel. This is an area that can give rise to a significant amount of anxiety because we've all heard the horror stories out there where somebody travels internationally, they can't get back to the United States, maybe they lose their job, they have to return to their home country. And while that's very rare, it can happen. And so being prepared for your international travel is important. And one of the main things you need to do is be sure that you have the right documentation. Whether you're applying for a visa or not, I recommend that you carry your I-797 approval notice, a recent letter from your company confirming employment, and then recent pay stubs also confirming employment. If you're traveling with a spouse or children, you should bring a copy of your marriage certificate and the birth certificates for the children. If you do need to apply for a new visa, I recommend that you apply in your home country whenever possible. The reason is security delays do happen, and if you're in your home country, it's possible that you might be able to continue working and not miss a beat. Whereas if you apply in a country that is not your home country and you don't have work authorization, you might be stuck and looking for a new hobby while you wait for your visa to get approved. One additional tip for my friends from India, and that is that you may qualify for an interview waiver, often called the India drop box. If you have had a US visa previously and you're applying for a new US visa in the same status, you may qualify. I'm going to include in the notes section below a link to all of the locations for the India visa application centers in case you do think this applies for you. As you probably know, H-1B status is good for an initial period of 3 years, followed by a 3-year extension for 6 years total. And if you take certain steps toward the green card process, you can really be in H-1B status almost indefinitely while you're going through the green card process. Now, one of the questions that comes up is, when should I apply for that extension? You can apply up to 6 months in advance. And one of the issues that comes up is that LCA I talked about previously that needs to be posted with the Department of Labor. If your law firm is processing a lot of cases, they may post that LCA 8 months in advance. And that means your H-1B extension will likely get cut short by 2 months at the end. It's not a big deal. You're still entitled to those 2 months. But a lot of times people wonder, why didn't I get the full 3 years? That's probably what happened. A term you might come across at some point is benching. This is the informal term for an illegal practice wherein a company places somebody in H-1B status on unpaid leave for a period of time. I'll give you an example of how this can happen. Let's say you come to the United States to work for an IT consulting company. They have a contract with IBM. You start doing work based on that contract, and then that contract ends. IBM decides not to renew for whatever reason, and so your employer is now looking for a new position for you, and during that period of time while they're looking, they don't pay you. That's considered illegal. That's benching. Now, if you request time off in accordance with company policy and standard vacation timeframes, that's totally fine. Nobody gets in trouble for that. This segues nicely into the ugly topic of layoffs. If an H-1B employee is separated from their employer for one reason or another, that company is required to offer to pay the cost of the return transportation to that person's home country. Now, most people in H-1B status will turn that offer down because they want to stay in the United States. They're here for a reason. If that's the case, then they have a 60-day grace period to either find a new company to transfer their H-1B to or to change their immigration status. For example, if your spouse is in H-1B status as well, you can change your status to H-4 while you're looking for a job. You can be here in a legal status, and when you find a new job, change your status back from H-4 back to H-1B. Okay, as promised, let's talk about green cards. For those who are interested in staying in the United States on a long-term basis, this is the best way to do that. Now, the issue that comes up is timing. Processing times have been increasing significantly, and so my recommendation is that you need to start the green card process no later than the end of your 4th year, and really preferably no later than the end of your 3rd year. Now, most companies will start your green card process after a certain period of employment, whether 6 months or 12 months or whatever it is. And so typically this doesn't become an issue unless you've been with your company, let's say for 2 or 3 years, you decide to take a job offer from a different company. It's likely that new company is going to need to start your green card process from the beginning. And that's a situation where you might run into a timing issue. So my recommendation is if you're going to make that kind of a change, make sure you figure out the timing issue, consult with your immigration attorney to make sure that you're not going to run into a situation where you might need to return to your home country for at least a short period of time. Okay, we covered a lot of material in a short period of time. I'm going to include our contact information below. Feel free to reach out with questions. We would love to hear from you. Thanks for joining me, and we'll see you next time.